Hi, I'm Charles with Gill, Denson Company, and I'm here to talk about binding arbitration and litigation in property tax appeals. So, binding arbitration and litigation are advanced forms of appeals reserved for certain types of properties and certain types of cases. Less than 1% of cases go to binding arbitration or litigation. So I'm going to take a step back and talk about the first two phases. So the first phase of any property tax appeal is an informal settlement period. Essentially, we go in and we have settlement conferences in person, on the phone, on Zoom with county appraisal districts. We're going back and forth many times to negotiate a value. It's much different than the way a property owner would. I think with most counties these days, the property owner gets an offer to go away, a 1 or 2% offer, and that's the informal period. That's very different from us because a lot of our work can actually happen in the informal period where we can sit across from an appraiser, talk about the facts directly, negotiate, and come to agreements that are realistic and that are strong, and they're not subjected to an ARB panel. And that's actually critical to our strategy in certain counties. So that's the first stage. That can take many weeks. It can actually take a few months depending on the case and depending on the county's availability. So we're constantly in informal hearings. We then have formal hearings. It's called the ARB, the Appraisal Review Board. That's when there is a panel of 3 citizens that hear our case, first the county, and they determine the value based on the arguments that were presented. ARB hearings can go great. We do them all day long, or they can, in our opinion, sometimes be biased towards the county. So we are always weighing that risk versus what we should do in an informal settlement. So there's not necessarily one good way or the other. It's case by case, county by county, even appraiser by appraiser. Our experts, our team that's been doing this for dozens of years, knows when a good offer is on the table that we've negotiated to take it to either way. So from there, once we complete those stages, if we believe we have not gotten everything done realistically from a value standpoint, we're going to let you know. We're going to say, hey, we actually end up going to the ARB hearing. The ARB provided a value that wasn't sufficient to our standards, and we believe we should appeal this further through a litigation or an arbitration appeal. And so with binding arbitration, there's a lot of specifics, but from a high level, it has to be under $5 million or a homesteaded property. And it's basically an expedited litigation so that us and the county can continue the appeal, and it's overseen by the state of Texas Comptroller's Office. So within 60 days of the ARB hearing, we have to file for binding arbitration. We do all of that paperwork for you. It is something that you have to agree to, though. We're going to call you and reach out and let you know, here's what we're thinking. Do you want to do it? And if you do want to do it, then there's a filing fee associated with it. It's not a filing fee to us. It's a filing fee to the state of Texas Comptroller. We collect it from you and pay it directly to them. From there, we have the paperwork is filed, and then there's a waiting period. So the waiting period is something that is a gray area. Usually it's about 6 months. It can be longer. So what we're waiting on is the state of Texas Comptroller to accept the arbitration and open up a new settlement period with the county. And so our goal, again, is to try to get in there and settle it with them. There's a 45-day period that we can open up discussions, and quite frankly, this creates a lot of leverage for the property owner. There's a lot of administration and a lot of work that goes into it for us, but the good thing is that it also takes a lot of administration for the county, so they're motivated to negotiate with us and to possibly avoid an arbitration hearing. So if we go through that period and we are able to settle your case, you actually get pretty much most of your filing fee back. You get all of it back but $50. So the lowest filing fee is $450, If we go in and we settle it, it's $400. The fees range from $450 to about $2,000 for binding arbitration, depending on the size and type of your property. So that's if we go in and we settle it. If we do go to a hearing, which is totally fine as well, it's us versus the county in front of one arbitrator. The arbitrator is typically a person that may be a former judge, they may be a real estate appraiser, a real estate attorney, a broker, someone in that background that's qualified and is monitored by the state of Texas comptroller. Here's our case. If we do win the hearing, you get the filing fee back less $50 again. To establish a win, that's the midpoint between our value and the county's value. So you could actually still go in and get a reduction and get the filing fee back, or you can go in and get a reduction and not get the filing fee back. So it's important to us that we do try to settle it because we are conscious of your filing fee, but we're gonna be talking to you about that. And if the case presents itself that we need to go to the hearing and put the fee at risk, you're going to be aware of that and help us make that decision. So that's binding arbitration. Litigation is reserved for properties typically over $5 million. It just depends on the situation. It's reserved for commercial properties, and litigation is a scary word in a sense, but it's a judicial appeal as your last line of defense against the county to appeal values. So large properties, large commercial properties that you know of, big box stores, they are constantly in litigation against the county appraisal district to achieve their fair market value. And so that process does take time. It usually takes about a year or two to go through the judicial appeal process, and our team is here to help do that. Typically, it's about a $500 give or take filing fee. We collect that and pay it for you to the county court, and then we continue to work off contingency as well. If there are any hard costs, we ask you if you want to incur those costs, such as getting an appraisal, getting a survey, and that those costs would be your responsibility. But we do continue to work on performance. And typically our cases, it is just continue to be a contingency fee. We don't charge like a typical lawyer would, like an hourly rate or a retainer. It's just an extension of the protest that you already have. So in both scenarios, it's something that we need to be willing to take on, that you have a realistic shot. You need to be willing and able to take on that level of appeal and give us approval. And then we do work on a contingency fee plus 10 percentage points of your contingency rate. So both great tools for property owners. It's not for every property owner, but our attorneys and our consultants do win cases in litigation and arbitration every month of the year, and would be happy to help. So contact us if you do believe your appeal should go further, and we are happy to help.